Hello folks, welcome to the Edupedia world and I am Abhinay Gupta. Today again we'll continue with the topic the SARFAESI Act 2002, which is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. And in our very previous lecture what we had seen was section 17, where we had seen the right to appeal, where we had seen that the borrower or any other person on its behalf has the right to appeal to the debt recovery tribunal against the recourse taken by the secured creditor, and that has to be done within the period of 45 days, right? And then the debt recovery tribunal would analyze and assess whether the action undertaken by the secured creditor is as per the provisions of the act, and if it is so, then notwithstanding anything contained in any other law for the time being in force, that act would be valid, right? And if it is not as per the provision of this act, right, as per the provision of SARFAESI Act 2002, then the action should be considered to be invalid, and whatever action has been taken has to be restored, right? If the management has been taken over, it has to be restored into the hands of the borrower. If the asset is taken over, it has to be restored into the hands of the borrower, right? And then the debt recovery tribunal has the duty to dispose of the application within a period of 60 days, or that can be extended to the maximum of 4 months. And if that cannot be disposed of within the specified period, then the matter is considered forward for section 18. So today in this lecture we'll understand what section 18 has to say. So as per section 18, appeal to the appellate tribunal. So appellate tribunal is the next authority. So if the debt recovery tribunal fails, or if you have any complaints, or if you are aggrieved by the debt recovery tribunal, you can appeal to the appellate tribunal. So the borrower or any other person, whoever is aggrieved by the debt recovery tribunal, either because they're not able to dispose of the matter, or they have given a decision by which the party is aggrieved. So that party, the aggrieved party, right, would raise another application along with the prescribed fees to the appellate tribunal this time, right? So to appeal against the order of the debt recovery tribunal, you will have to approach to the appellate tribunal, right? So you will have to pay additional fees over here and mark an application to them. And this process has to be initiated within 30 days. Now, within 30 days from what? From where do we start counting the period of 30 days? So the period of 30 days would be counted from the date of receipt of the order from the debt recovery tribunal. So whenever you receive an order and if you are aggrieved by the order, so within the period of next 30 days, you can apply to the appellate tribunal with an application and the prescribed fees, right? And along with that, you will also have to deposit 50% of the amount that you have borrowed. So if the borrower for example has borrowed 1 crore rupees from the bank, right, and now the asset has been transferred to the Securitization and Reconstruction company, so what they will recover from the secured creditor, from the borrower or the obligor, is rupees 1 crore, right? So now if the debt recovery tribunal also decides that okay, the steps taken by the secured creditors are right, and then the borrower will have to pay, or his assets will be sold, or the management will be taken over, whatever be the course of action as per section 13 subsection 4, right? And then the borrower is now aggrieved and now it wants to file an application to the appellate tribunal. So 50 lakh rupees, that is 50% of the amount that it had borrowed, has to be kept as a secured deposit with the appellate tribunal before filing an appeal, right? Because if the debt recovery tribunal is already in favor of the secured creditor, right, that means that means there is a great chance that the secured creditor is going correct, and that the borrower is not willing to give the money of the secured creditor. That is why at least 50% of that amount is kept as security with the appellate tribunal. That okay, if appellate tribunal decides it in favor of the secured creditor, then this amount can be paid to them, right? Now when we talk about 50% of the amount borrowed, now how do we decide what is the amount borrowed? Either it is in the documents the original amount borrowed, right, which is claimed by the secured creditor that okay, this person had borrowed 1 crore from me and now we want the 1 crore back, right? And there may be a scenario that the debt recovery tribunal is under some other opinion, and either there are some more accumulation, some more cumulative amount that combines and increases the debt, increases the amount borrowed by the borrower. Maybe it goes up from 1 CR to 1.1 CR, right? And in any scenario, it can also be reduced, right? That is when the borrower has been paying certain amount of interest and principal, right? So that amount has to be reduced. So we won't be blindly going with what they had originally borrowed, right? Maybe they had borrowed 1 CR, but till date they have already paid 50 lakhs and they're not able to pay the other 50 lakh for which the account has been transferred to the secured creditor. The asset has been transferred to the Securitization and Reconstruction company. Now the Securitization and Reconstruction company wants to reconstruct the asset and gain that 50 lakh rupees. So that doesn't mean that they will have to deposit 50% of the borrowed amount. That is, they'll have to deposit the entire 50 lakh. No, because when you are approaching the appellate tribunal, that means you have already passed the ladder of the rung onto the ladder of this hierarchy, and you have got the judgment of the debt recovery tribunal.
Then the secured creditor
the debt recovery tribunal, after getting through the entire accounting and entire procedure,
we come to an
and the entire transaction, would decide that okay, 50 lakh rupees is pending.
For the upcoming
now they will have to deposit 25 lakh from that 50 lakh rupees.
Thank you. Bye-bye.
Right? And then this deposit of 50% can also be relaxed, right? And that can be brought down to the minimum of 25% for some special reasons. Right? And that special reason is not very important, not very specifically given in the Act, but there can be anything, any special reason due to which the appellate tribunal may require a deposit of just 25% of the amount borrowed. Clear with that? So next, section 18C deals with the right to lodge a caveat, right? So the first thing is, what is a caveat, right? So caveat is nothing but a notice that certain action may not be taken without informing the person who has given the notice, right? So a caveat would require you to inform the person giving you the caveat, giving you the notice, that okay, this is going to be done now, right? So what does that mean in this scenario? We'll see now. So when an application or appeal is expected to be made, so who makes this expectation? This expectation is made by the secured creditor, right? Because after the decision of debt recovery tribunal has been filed, had been given, then that is in favor of the secured creditor, and the secured creditor is now under a suspicion that maybe the obligor or the borrower would approach the appellate tribunal, right? Would file an application or make an appeal to the appellate tribunal. So in that case, what they can do is they can lodge a caveat to the borrower, right? So what happens is that the secured creditor or any other person on its behalf can send a notice, right? And that can be sent by a registered post with which you will attach an acknowledgement due, that okay, that the other person has received it, it's a confirmation, right? To the person who is making the application. That means the borrower or any other person in place of the borrower, right? So a caveat is a notice, and according to that notice, the person making the application will have to inform the secured creditor that okay, this application is going to be filed, that yes, I'm going ahead with this kind of an application to the appellate tribunal, right? So what happens after the caveat has been lodged? Now take a scenario where Mr. X was the borrower and Mr. A was the secured creditor, right? And Mr. A has given a notice to Mr. X, right? So what happens is that Mr. X writes an application to the tribunal, appellate tribunal, or in a district court, right? Or to the high court. Whomsoever, these are the four bodies where they can make an application against the debt recovery tribunal, right? So when they make an application to any of these four bodies, right, then they will have to send a notice of this application to the caveator. Caveator is the person who initiates the notice, right? The person who sends the notice to the other person. So the person sending the notice, who seeks that information, is known as the caveator, right? So as per the caveator, the notice, right, the application made to any further body, which is the tribunal, district court, or appellate tribunal, the high court, that application has to be informed to the caveator that yes, this such and such application has been made, right? That is the concept and that is the requirement of a caveat, right? And then the person making the application will also have to periodically send the copy of the application plus other documents that the caveator would require from that person, right? So under section 18, what you have understood is the right to lodge a caveat. First thing is, what we understood is what a caveat is, right? It is a notice which would require the receiver of the notice to inform the sender of the notice before taking any action as per the requirements of the notice, right? So the secured creditor may send a caveat, may lodge a caveat, right? Send a notice to the borrower, and when the borrower makes an application to the tribunal, district court, appellate tribunal, or the high court, then a notice for that application has to be sent to the caveator, right, by that body. And the person to whom that notice was furnished will also send an application, a copy of the application with other relevant documents to the caveator, right? So this is the provision of section 18C, right? So far all the procedures have been done. In section 17 we had seen about the debt recovery tribunal. Then we had seen section 18 where an application can be made to the appellate tribunal, how and who can make it, how can it be made. And then in 18C we talk about the concept of caveat, right? Now the case has already gone to the tribunal, the district court, the appellate tribunal, or the high court, and they will look into the matter and decide and give the final decision as to what is to be done, or whether the decision of the debt recovery tribunal was correct, or whether there has to be some modification into it, right? Or whether that entire decision will be ruled out. So the next provision is provision of section 19, which says the right to receive compensation. So consider a situation where the debt recovery tribunal or the appellate tribunal, right, gives the decision in favor of the borrower, right? Whether it's a debt recovery tribunal or the appellate tribunal, they decide the conclusion of the case in support of the borrower. Then that borrower would be entitled for compensation, right? So the secured creditor would now restore whatever action had been taken, whatever recourse had been taken. For example, under section 13 of section 4, if they had overtaken the management of the borrower, they will have to restore the management to the borrower. If they had taken away the asset, they'll have to give it back. If they had assigned a manager, the manager will be called back, right? So whatever action had been taken will have to be reversed now, right? It has to be restored. Plus a compensation, additional compensation will have to be paid to the borrower, right? That compensation would also include the cost that the borrower had to bear due to the action taken by the secured creditor, right? And that compensation and cost may be determined by the tribunal or the appellate tribunal, right? By any of the two bodies that have. So I hope now you're clear with section 19, that if the debt recovery tribunal or the appellate tribunal decides to support the borrower, then the secured creditor would have to return the asset and also bear the compensation, right? So with that we come to an end of section 19 and the entire lecture. So stay tuned for the upcoming lectures, and until then, this is Abhinay Gupta signing off. Thank you. Bye bye.